Good morning, everyone, and welcome to today's webinar, International Law, a legal primer exploring key business issues for the U.S. and foreign entities. My name is Lexi Sychik, and I'll be your moderator. I work on the marketing team here at White & Williams, and I'm excited to be hosting this session. We thank you for joining us today. At this time, I would like to introduce our speakers, Jim Anelli, Gary Bean, Scott Kasher, Jared Johnson, and Bruce McLennan. Jim is partner with over 35 years of experience handling a wide range of labor and employment matters. He focuses his practice on guiding employers in addressing employment benefit matters, defending employment discrimination claims, negotiating executive employment agreements, handling complex fraud and governance matters and high-profile investigations for management, and providing guidance to international companies on U.S. employment laws. Gary is partner and focuses his practice on assisting clients in forming strategic partnerships and pursuing business opportunities in China and Europe. Gary frequently counsels clients on forming domestic and international commercial relationships, including joint ventures, partnerships, and strategic alliances. Scott is partner and is a skilled litigator who represents a variety of business entities with respect to commercial matters, insurance coverage matters, restrictive covenant and non-compete matters, and labor and employment matters, including Title IX claims in state and federal trial and appellate courts, and arbitrations and in mediations. Jared is partner and provides tax representation and guidance on complex tax laws and disputes, corporate transactions, reporting, asset protection, and cross-border issues. He regularly assists in compliance with Internal Revenue Code, as well as the Employee Retirement Income Security Act of 1974, or ERISA. Bruce is partner in the firm's international and corporate and security groups. He advises his clients based in the US, Asia, and Europe, and the UK on structuring and executing complex cross-border business transactions, principally in the areas of private investment, fund formation, and the structuring of pooled and individual investment vehicles, private equity and venture capital investments, secondary market transactions, mergers and acquisitions, and the structuring of joint ventures, strategic alliances, and customized business partnerships. And with that, I'd like to hand it over to Jim Anelli.
Good morning, and thank you for attending today. I'm very excited about the program that we have. It really is a comprehensive overview of the types of issues that companies have been dealing with who are operating in foreign countries around the world, coming into the US and setting up local operations, subsidiaries, or acquiring new companies here in the US. Today, we have a very broad program covering some 8 areas, including the introduction concerning the interplay of basically federal, state, and local laws and how they impact your business in the U.S., a discussion about equity financing in the U.S., a question as to whether you can conduct business in the U.S. under a statute called CFIUS, tax considerations, also an overview of the differences that you may see in the U.S. with respect to labor and employment laws, a discussion about non-compete agreements and employment agreements in general that are fairly standard here in the US, IP considerations for operating in the US, and lastly, insurance questions and what types of insurance are prevalent here in the US for various types of claims. So without wasting any time, why don't we get into a discussion understanding the interplay of federal, state, and local laws. One of the things in dealing with clients who are operating in Asia or Europe, or the parts of the South America, is the dichotomy that exists in the operations that they experience locally, where they may just be involved in one set of national laws and regulations. Compare that to the US, which is really sort of a patchwork quilt type approach to laws and regulations that would impact operations here in the US. One of the questions I think that company owners and company managers will have to ask themselves is what type of activities will we be engaging in the US, and what does the regulation platform look like locally? Unlike many countries, the US has a complex panoply of federal, state, and local laws that apply to a variety of key legal areas. For example, let's just talk about one fairly simple question. Actually, it's not so simple, which are wage laws. Wage laws can vary greatly, not only among the federal laws that would govern wage payment, overtime, but also state laws can be quite different with respect to withholding requirements and classification of whether a worker is an employee or an independent contractor. But there are also local legal requirements at the city level. So depending on where you're operating within a particular state, there can be quite a different variation in the outcome of a particular wage question. So as you can see, there is no preemption by federal laws. There often is in connection with other foreign countries. And this is, when I counsel clients coming into the US, this is one area that we spend a lot of time on because it's quite different than what they're used to. Next slide. In the employee benefit area and in the labor relations area, it's often exactly the opposite, where federal law preempts state and local law so that on a national level, if you have employees within a number of states here in the US, there often isn't that dichotomy that we see in the wage area. In the tax area, like the wage area, there are often state, federal, and even local requirements. Many cities have their own tax requirements. So again, it's important particularly at the local and state level, to make sure that you have counsel in that area, whether it's a legal counsel or tax counsel. It's important to understand that before you begin operations. Accordingly, the US can be a very complex country in which to operate, particularly if you're subject to numerous regulations. Another example would be environmental laws. If you're opening up a production or manufacturing facility, depending on what you're manufacturing, there can be a host of local, state, and federal laws. And so local counsel is often necessary to assist companies coming into the US as to what law applies to their operations. Next slide. So for example, one I think easy example to point out is California. So if a company is looking to go into California, they would really have to weigh the business advantages of operating in California against the fact that California has an extensive set of local laws that are far different than many other states in the United States. And the way to really look at this is to really early on in the process is discuss with it could be a consulate, it could be counsel, it could be an accounting firm who have a really good grasp on what the laws are within a particular state to assist you in that regard. Another trend that companies are facing here in the US because of the pandemic is that we now have employees working remotely in many, many different states, so that employers who only had employees, say, in 2 or 3 different states now may have employees in 10 or 20 states. And here in the US, as we'll talk about, it's the location of where the employee works, which often determines what law applies. Next slide, please. And with that, we'll be getting into equity financing in the US. Bruce?
Thanks, Jim. Good morning, everyone. Thank you for joining us today. It's great to see everyone here or have you here. My name is Bruce McLennan. I'm a partner in White & Williams International and Corporate Securities Practice Groups. And I will be speaking for the next few minutes about some of the important considerations that a foreign company will need to take into account when seeking third-party equity investors to help finance your subsidiary operations in the United States. Given the short time we have, we'll just take a quick look at a few of the key issues. Next slide, Lexi. One of the most important threshold questions for the foreign parent that the foreign parent will need to address is what sort of investor would make the best fit for my company and its objectives. Different classes of investors will bring different mixes of terms to the negotiating table. For our purposes here, we've assumed that the foreign parent company is an established enterprise and will not be launching a new startup. So you won't be looking for seed capital, for example. But rather you'll be expanding your existing operations into the US market. And in that scenario, the most important classes of investors or appropriate classes for the company to consider would be institutional venture capital firms that provide equity capital and strategic investors, US companies with their own established operations and networks that may be interested in capitalizing on synergies by joining hands with your foreign company new to the US market. In the next two slides, we'll take a look at the differences in approach between these two classes of investor. The US is the largest market for venture capital in the world, as you're probably already aware, and venture capital is perhaps more readily accessed in the US than in any other country. In seeking venture capital to help finance US operations, however, it will be very important to understand the venture capital model. The ultimate goal of the typical venture capital investor is to maximize its equity stake in the investee company, help grow the company and prepare it for an exit, and then, in a matter of a few years, realize its upside on an exit event, typically an initial public offering, listing the shares on an exchange, or a sale of the company. Next slide, Lexi. An important consideration for the company in negotiating a VC investment is which entity's stock will the VC receive. This is usually a heavily negotiated point. The VC will typically want stock in the entity that either owns the company's core assets or has rights to those assets. And the more irrevocable the rights are, the better. The VC will also want to participate in a sale or listing of the parent as well as the subsidiary. And as such, the VC may prefer to invest in the parent or in both the parent and the subsidiary. So the structure of the investment on the VC side will be a threshold negotiation. Turning to strategic partners like the VC, a strategic investor will bring needed capital to the company. But unlike the VC, however, the strategic partner may be more interested in the long-term business growth and revenue generation that can be achieved by partnering with your company, rather than focusing on reaping upside in an exit a few years down the road. The strategic investor will want to participate in some level of management decision-making and will bring its own assets to the table, perhaps in the form of technology, expertise, or an existing marketing and distribution network. Similar to the VC, a strategic partner is likely to want equity in the entity with ownership of rights to the core business assets and will demand a stake, could demand a stake in both the parent and the US subsidiary. In addition, the strategic partner will be looking for direct access to the company's technology or proprietary business know-how that may be essential for the success of the business lines to be developed jointly with the company. Next slide. VCs will pay a premium for their equity stake in the company. So the capital that may come into the company in a VC investment may exceed that you would find in a strategic investor investment. But the VC will expect to receive in return preferred stock with rights and preferences that will multiply the value of their investment when it's time to cash in on the IPO or sale of the company. So the VC will want features attached to the preferred stock, such as the right to convert each share of its preferred stock into multiple shares of common stock when there's an IPO or a sale of the company. They'll be looking for the right to receive dividends and distributions on the liquidation of the company prior to the holders of the common stock. Now, they'll be looking for the right to purchase a pro rata share of stock issued in future financings. And they'll be also looking for assurances that they'll be able to include all or a negotiated portion of their shares in an IPO of the company. Next slide. By contrast, since strategic investors are more interested in enhanced long-term business expansion and revenue generation that will be achieved through the strategic alliance with your company, strategic investors are often issued common stock at fair market value without paying a premium at the time of issuance, without the enhanced rights and preferences that come along with preferred stock. The strategic investor may also receive founder stock in the foreign parent, and that's something that you'll need to be aware of and ready to negotiate. And the foreign parent may have the option to acquire shares in the strategic partner as well. In considering a strategic relationship, the company will need to weigh the opportunities that the strategic investor may provide in facilitating the company's entry into the US market against the risks of a long-term commitment to a partner with access to your technology and proprietary business information. Next slide. When the company is ready to issue shares in the US subsidiary to one or more investors or in the parent company, it will need to ensure that the issuance complies with the requirements of US securities laws. The Securities Act of 1933 requires that the offer and sale of securities to investors in the United States must be registered with the Securities and Exchange Commission, the SEC, unless the offering is eligible for an exemption from the registration requirement. Fortunately, the Securities Act provides an exemption for private placements of debt or equity securities that are sold by a US or foreign issuer to accredited investors or qualified institutional buyers in the US under Rule 506B of Regulation D under the Securities Act. Accredited investors include, among other things, any entity that owns investments in excess of $5 million. Virtually all venture capital firms meet this requirement. Strategic investors that may not hold $5 million in investment can still qualify if they're a corporation, partnership, limited liability company, or tax-exempt organization with at least $5 million in assets, or all of their equity owners are themselves accredited investors. Next slide, please. Rule 506B under Reg D requires that the issuer reasonably believe, and the issuer is, of course, either your foreign parent company or your US subsidiary, reasonably believe that the investor qualifies as an accredited investor. If the issuer sells its unregistered securities, however, to an unqualified investor, the issuer, your company, may not be able to rely on the private placement exemption. Moreover, selling without a registration statement or a valid registration exemption gives each purchaser of your securities, not just the unqualified purchaser, the right to rescind or cancel its purchase and recover the purchase price plus interest from your company for 1 year after the sale. To avoid this strict liability and protect the exemption, issuers rely on investor questionnaires, which require the investor to represent and warrant that they qualify as an accredited investor. In addition, issuers relying on the Reg D private placement exemption are required to file a Form D with the SEC after the issuance. All issuers involved in an offering are required to file the Form D. If both the foreign parent company and the US subsidiary are issuing shares in an investment round and relying on the Rule 506B exemption, then both entities, the foreign parent and the US subsidiary, would make separate Form D filings. Fortunately, Form D is a relatively short and simple filing, and Once the Form D is filed, there are no further filings or updates required. Next slide, please. As Jim mentioned earlier, the United States is a regulatory patchwork, and that holds true in the securities regime as well. In conducting an offering of your shares to investors in the U.S., your company, the foreign parent and/or the U.S. subsidiary, must comply with the securities laws, not only the federal securities laws, but the laws of each state in the U.S. in which the shares are being sold to investors. And as there are 50 U.S. states, each with its own securities regime, this can be an expensive and tedious undertaking. Fortunately, however, state securities registration requirements are preempted under the National Securities Markets Improvement Act of 1996 if the private placement satisfies the requirements of Rule 506 of Reg D. Accordingly, your company, your foreign company, and your U.S. subsidiary, when issuing preferred or common stock to a venture capital firm or a strategic investor that qualifies as an accredited investor in reliance on Rule 506B of Reg D, will automatically be exempt from registration in any U.S. state. However, there may be, similar to the Form D on the federal level, the states that you're issuing in may require a brief notice filing. And with that, I'll turn it over to Gary Bean, who is going to talk to you about the Committee on Foreign Investment in the U.S., which affects the investments that I just talked about and other things as well.
Great. Well, thank you, Bruce. And I'd like to extend my welcome to everyone this morning. And it's a good segue, Bruce's overview of how to structure investments in the United States. As Bruce said, my name is Gary Bean. I chair the International Practice Group at White & Williams and have been involved with international trade and international transactions for over 25 years. So what is CFIUS and what do you need to know about it? Next slide, Lexi. So as Bruce mentioned, CFIUS is the Committee on Foreign Investment in the United States, and it has the authority to review national security implications of certain covered transactions. It's actually something that's been around for quite some time. It flows through the executive branch, and it started first back in 1975. It's a multi-department committee. It's led by the Department of Treasury, and there are representatives on the committee from Defense, State, Justice, Energy, Commerce, and Homeland Security. And as you can see, the jurisdiction is very broad, and there are certain very key defined terms that I'm going to review today. And bottom line, the committee has the ability to block or unwind any covered transaction if it's deemed to threaten national security. It's gone through some very significant changes in the last several years. The focus used to be much more on transactions that are involving acquisitions near military bases, near critical infrastructure. But 2 years ago, or 3 years ago, I should say, there was enacted what was called the Foreign Investment Review Modernization Act of 2018, and that became effective in 2020. And it greatly expanded the scope of CFIUS. Now it not only applies to controlled transactions, but in certain circumstances, certain industries, it also applies to non-controlled transactions. So as Bruce was saying, if you're structuring a transaction where you're at a certain round of the transaction, this is something that you need to be aware of. It also goes into new requirements for mandatory filings, and then it also introduces a short form declaration which I'll also get into. So if we can go to the next page, please. So under what's called FIRMA, the new act, the first level of scrutiny, you have to look at the transaction itself. And covered transaction, it's defined very broadly. So it's mergers, acquisitions, takeovers, stock sales, asset sales. Also, joint ventures can be covered. And then you also now, under the new requirements, also look at non-controlling investments. But it really is critical what business line, what industry are you looking to make the investment? And under this new act, they have defined something called TID US businesses or TID US businesses. TID stands for T is for technology, I is for infrastructure, and D is for data, actually personal data. So these are the areas of scrutiny under CFIUS. If you are going to be making an investment in these areas, then you have to really look very closely on whether that investment will trigger a requirement either to make a voluntary or a mandatory filing with CFIUS. So on the technology, it's actually under the Act defined as critical technology. And it is, as you can see from the list there of covered transaction, it's a very broad definition. And as you can also see, it's areas where the US government has defined that these are of national concerns or interests. It covers anything that may be subject to export control. And as you can see, it also involves emerging technologies. And it's broadly applied. So if you are making an investment in a US company that either designs, tests, manufactures, fabricates any of the critical technologies that fall under the definition, then you may be subject to a CFIUS filing. The critical infrastructure, that's something that's similar to how it's always been applied. And then the newer area is companies that maintain or collect sensitive personal data of US citizens. So that's an area of consideration as you're evaluating whether to make an investment. If we could go to the next slide. So filing with CFIUS, there are several methods that trigger the CFIUS review. As I mentioned, there's a new approach, which is called a declaration. And it's often used if your acquisition is in an area that is not of great concern, but still triggers a filing. And that is evaluated as you're making that decision and working with counsel on, it differs from the country from which you're making the filing, and I'll get into that in a moment, and then also the type of industry that you're involved with. So an initial decision that you make is, do you go through the declaration process? It is designed to be streamlined. It can take only 5 to 6 weeks. Most of the filings go in through a joint voluntary notice process. And that's an area that we've worked closely with clients in making those voluntary filings. And often it's done by both parties to a transaction. And then, as I mentioned, in certain areas, the filing is mandated if it's a controlling interest or a covered transaction that I referenced before. And then there's an other arm of CFIUS that looks only at real estate transactions, purchases, leases. And again, this is something that has been scrutinized by CFIUS historically. This is where if you're making a real estate investment near a sensitive government facility, that may also trigger a filing. If we could go to the next slide, please. And so let's drill down a little bit on mandatory filings, because this is the new area. And this is an area that often, as you're making an investment from overseas, it may not jump off the page that this is an area that may be subject to CFIUS filing. As I mentioned previously, it had to be a controlled transaction. But now, if you're investing, making a substantial interest in a company that qualifies, and again, it's one of these TID US businesses, and you would first look to see if the technology of the company, it falls within that definition. And if you're making a minority investment, and that's often, in my experience, how foreign companies come to the United States. They make a minority investment, they test the waters, they get involved, they develop a relationship, and then, often with that investment, they may have the opportunity to make other rounds of investment and possibly to acquire the company itself. But at that initial investment stage, you have to structure it or be very mindful when you're structuring whether you're going to trigger a CFIUS filing. So, for example, if as part of that investment, you have access to non-public technical information, and again, it's critical technology, that may very well trigger the filing. Board membership observation rights by themselves can trigger the filing. And then any other involvement with substantive business decisions can trigger the filing as well. So it's an evaluation that you want to do early in the process. If you are triggering the filing, then the decision tree, do you make a voluntary filing? Do you have to make a mandatory filing? You have to start that process early. And then let's say you confer with counsel, you go through the checklist, you do the evaluation, and you say, well, we don't have to make the filing this time. You have to be mindful at any next round of investment, whether that might trigger a filing. So anytime you're making an investment, you have to go through the steps to see if it triggers the filing. Let's go to the next slide, please. And again, most of the filings are voluntary filings. It's made on a confidential basis. You log into the portal at CFIUS. And the first step is there is a 45-day review of the transaction. During this process, and as I had mentioned before, it all flows through the Department of Treasury. There will be representatives of Treasury. They'll interact with you as you're making the filing. They will ask questions, you'll respond to the questions, and several things can happen after that voluntary initial filing. It could be that the committee raises issues and they ask for conditions for clearance, mitigation conditions, such as, let's say the only thing that really triggered the filing was board rights. They may come back and say, we can clear this transaction if you do away with the board rights. Or they may come back and say, we can clear it if there are certain covenants, limitations of access to certain technical information. Or they could just come back and clear the transaction itself. And then if they do not clear the transaction, it could go to the next stage of an investigation. So that triggers a further 45-day period. We were working late last spring on a transaction. It involved an investment and through South American company, but that South American company had some shareholders from China, and it was in a critical technology. It triggered an investigation. We were literally at the 44th day hoping to get a letter of clearance, and instead we got a letter of investigation. So what happens when there's an investigation? It accelerates the information that the committee's looking for. And so in the matter that we had last summer, there were many follow-up informations asked. And the key to that is to continue to have a good relationship with the folks you're working at Treasury, be very prompt to get the information together, and be as clear as possible. Also during this period, you can request to meet with CFIUS. to kind of present your position if you don't believe that the questions are going down the right path. And then ultimately a decision is made. Fortunately, in our case, it was to clear the transaction. But if it is not to clear, then it could be a recommendation to the president. And the president has 15 days to make a final decision. And as I said, the decision could be to clear or could be to suspend or prohibit the transaction. Next page. I put this slide together because the history of CFIUS is, in a sense, very directly tied to China. And the FIRMA that I mentioned that came out in February 2020, it really addressed some concerns that were being seen in the marketplace. There was a very large concentration of filings coming out of China. And there was a concern at the national level here in the US about certain critical technologies. Now, as I mentioned in the first slide, it was, CFIUS started really focused on national security, but this latest round of the FIRMA Act really focused as much on national interests and certain industries that there was concern about access to technology, access to information, and some of that related directly to some of the investment activity out of China. So it's no accident that in that list of critical technology, you see references to semiconductors, nuclear, artificial intelligence, robotics, happens to be areas that we're in competition against China. And now, more recently, there's been a downturn in the number of filings out of China. And I note that in the first bullet point. Most people believe that it's twofold, the reason for the downturn. One is that there's more heightened scrutiny on those investments, but also, as everybody knows, there is remaining tension between the two countries. And that's also a reason that most people believe that there's been a downturn. I also point out that on the bottom bullet point that not only does CFIUS look at filings, but they also have the authority to look at transactions that they believe should have been subject to filing. And more recently, they've expanded the budget to do that. Each year in the summer, CFIUS comes out with a report looking at the prior year, and it really is out there for companies and practitioners to get an idea of what are the trends, what are the things that we should be concerned about. And in the latest report, they emphasized that they took a look at 117 non-notified transactions and actually initiated a request to make a filing in 17 of those. And one that I highlight as one where actually President Biden, the CFIUS recommended that the president block the transaction. When you look at it at face value, you might scratch your head. It involved a Chinese private equity firm acquisition of a South Korean company. And you think, well, what's the nexus? Well, the nexus there was, it was through a US company, and it involved the semiconductor industry. So it's an area, again, where there is concern, and it triggered a recommendation. Let's move to the last and final slide. I just point out a couple of things, and I'll start with actually the middle observation. It also depends where you're making your investment from. If you're a company in the UK, in Australia, Canada, New Zealand, you're going to be subject to a lower threshold. And let me explain that. Just this month, New Zealand was added to the list of what's called accepted foreign states. And the concept there is these are countries that have robust processes in place, legal systems in place to evaluate foreign investments. And many of these countries also share information with the United States. So New Zealand was added to that list. They now have a year to, in a sense, prove that they have this robust policy in place and it's working. Just in that information out of CFIUS, they confirmed that Australia and Canada have proven that. UK is still in the process. And folks believe that Germany and Japan may soon be added to that list. And I mention it because it's critical. If you're in one of those countries, you're looking to make an investment in the United States in one of these critical technologies, you may be exempt from certain covered transactions. And so it's very important, the country that you come from. Last comment is, and I just put it up there because, as Jim said, as Bruce said, we have a robust set of regulations in the United States, and in the current environment with some of the challenges we have, and again I'll use China as the example. You know, just recently there was a bill introduced that would prevent certain purchases in certain, again, critical technologies from any business linked to the Chinese Communist Party. That's just a bill. It hasn't been passed, but I think it shows you the trends of what you have to be aware of. There's also some discussion at the Department of Commerce of more scrutiny on certain transactions. So it's something that we at White & Williams, we stay abreast of it. It's something that you should think about as an investor to make sure that you're evaluating the opportunity appropriately. And so with that, I think I will turn it over to my colleague, Jared Johnson, who will go over some tax considerations with you. Thank you. I appreciate it.
Thanks, Gary. And to not put too fine a point on it, that the U.S. has very robust regulations. That's absolutely accurate, and it's not going to get any cleaner as I move through these tax considerations. In the U.S., we have ordinary income tax, capital gains tax, excise tax, property tax, sales and use. Just as a matter of exercise, the other day, I ran a quick search, and I came across a number of authors, tax experts, and each one, I saw 5 of them, and each one claimed that there were 3 different kinds of tax in the US, 4 different kinds of tax, 5 different kinds, 7 and 12. That's 5 authors, and none of them could agree on how many different kinds of taxes we have. So in order to bring some order to this, the focus of what I'm discussing here today, let's go to the next slide. I'll be talking mostly about the employee compensation and the taxes associated with employees. Now, of course, there are many other considerations. I'm going to focus on U.S. residents and non-residents, how that structure works, and then maybe touch on a couple other issues here towards the end. Let's go to the next slide. So when a company decides to come into the U.S. and engages either an independent contractor or an employee, there are a number of processes that the company is going to have to go through to determine its withholding obligation with respect to withholding tax and forwarding it to the IRS, or whether the individual has the obligation to pay that tax on their own. The U.S. has what are called U.S. persons. And in order to be a U.S. person, there is a residency requirement Typically, if you are not a US person, then the analysis goes into a whole, into another area. And that's where we're going to spend most of our time today. So if you're a US person, then there is a tax liability on that individual on all of their worldwide income, wherever located. Now, two things on that. First off, why do we care? If the employer fails to withhold and remit to the IRS, then there could be significant liabilities imposed on the employer. Now, if the employer feels that they themselves aren't subject to US tax or IRS jurisdiction, the question becomes, well, how's the IRS going to get me? It's not only that the IRS does find a way and will secure jurisdiction over an offending country, but also that power extends to the US Treasury. And the US Treasury has much more far-ranging ability to access overseas operators. So first off, that's why we care. Second, the US is fairly unique in that it imposes its taxes based on citizenship or the service provider's connection with the US, whereas the vast majority of countries around the world utilize a geocentric tax system, which is that income is based on where the individual is located or where services are provided. The US focuses on citizenship or sufficient contacts with the US in order to impose the liability. Now, what we will see is at times that winds up with folks bumping up against each other where they qualify to be taxed under both jurisdictions and what happens in that situation. So let's go to the next slide. So if you are a US person, there's a tax liability and there's an obligation. If you are a resident, then you are a US person. Now, if you're a non-resident, then we go into some other areas of analysis. First, who's a non-resident? If you hold a green card, then you are a US resident. The default consideration, is that a non-US citizen is not a resident. So in order to bring them into residency status, either you satisfy the green card test or the individual satisfies what's called a substantial presence test. Now there is a way to elect out of these tests, make it uncomplicated and just say, I'm a US resident and let's bring it on and let's get this over with. In order to elect out of those tests and become a US resident, then essentially it's that the individual can make the election. That can either be through a separate filing. They can make that choice in the first year that they're eligible. They can, if they are a non-resident spouse married to a US citizen, you can file a joint tax return and make the election. And that particular election is year by year. Each year you can choose whether to be taxed as a resident or not. Even if the individual has a closer connection to a foreign country, they can choose to be determined as a US resident. Now, under tax treaties, and what we will see is that tax treaties tend have the ability to modify all of these general rules. Now, there are form US tax treaties, and those that's what we will use today for most of the discussion. So if the individual falls under a US tax treaty, then they can claim that they are exempt from withholding. And there are some requirements there. If the individual can claim exempt status, then they will report all of their income on Form 1042-S. If they are not eligible to claim exempt from withholding, then their income is reported on Form W-2 by the employer, just like an ordinary US employee. So if If there's some on one, some on the other, then you'll have to reconcile both of those forms when the individual employee prepares their taxes for the year. The non-resident employee is also required to file a tax statement with governments. Even if they don't receive income during the year, they have to file an informational return. That's the form 8843. Let's go to the next slide. Okay, so the substantial presence test is a little bit more involved than just straight green card determination. It considers immigration status, the date that status began, how many days they were in the US, and why they were here. So let's go to the next slide. In order to meet the substantial presence test, there are two requirements. First, 31 days in the current year. The individual had to be in the US for at least 31 days. And the second requirement is that they had to have been in the US for at least 183 days over the last 3 years, the current year and the previous 2 years, but those days aren't counted evenly. It's a one day, it counts as 1 day for the current year, but for last year, for the previous year, it's a 1/3 to 1 day. So if they're in the US for 3 days, then only 1 day counts. And you go back 2 years and it's a 1/6 to 1 ratio. So just to illustrate that a little bit, we'll go to a couple examples. Let's go to the next slide. All right, so you have a non-US citizen, not a green card holder. They're in the US from February 1 to November 15th. This is pretty easy. They're in the US for at least 31 days of the current year, and they're in the US for at least 183 or more days this year. So the test is satisfied. Edward is a US resident. Let's go to the next one. This is a little bit more different. Let's say same individual. Edward is here in the US for 120 days during year 1. We'll say that's this year, year 1. And we'll go back to year 2. He was here 120 days last year. And then he was here 120 days the year before that. So looking at last year, 1/3 of 120 is 40. So we count 40 days last year. 2 years back, 1/6 of 120 is 20. So 120 days this year, plus 40 days last year, that's 160, plus another 20, 180. Edward is not a US resident under that fact scenario. Let's go to the next slide. Now, for an employer, we want to, oh, sorry, there's one more on tax residency. Yeah, let's go to the next slide. I mentioned that countries can bump up against each other in determining whether an employee should be taxed in one jurisdiction or the other. There are a series of facts that come into the analysis. Now, under this particular example, we've got an employee who's in the US for 183 days for the current year. So he satisfies the 183-day requirement. He's here with his wife. He operates a US branch of his Mexican company, but the rest of the time, he spends every vacation, every other weekend at his condo in Mexico City with his children. So this is a situation where it's right down the line. You have residency on both sides. Then the IRS will look to where the principal home is. In this particular situation, neither location can really be considered a principal home. Vital interests, which are personal and economic relationships. You've got companies on both sides of the border. You've got a wife here, children there. Very, very, very equal. And habitual abode is very equal. In this particular case, he's a Mexican citizen. And that's what it comes down to. That's ultimately the tiebreaker. Now, as I mentioned before, treaty agreements can settle a lot of these issues. And currently, the US has tax treaties with about 75 to 80 different countries around the world. Most of the time, you'll hear about 70 tax treaties. We count a little bit more because there are certain treaties, like the tax treaty with the USSR, where even though there's a separate treaty with Russia now, that treaty still applies to countries such as Kazakhstan, Uzbekistan, some of the former republics. So we've got about 75 to 80 different tax treaties, depending on, and each one could vary a little bit. Let's go to the next slide. Okay, so for an employer, what we recommend is that they maintain a form for foreign hires that contains all of the information necessary for the employer to make a determination as to residency, and therefore the employer's withholding obligation for the employee's tax liability. It includes everything that I've just discussed. Let's go to the next slide. As well as there on the bottom, you'll see additional forms. One of those is a W-8 BEN. That's where the employee claims to be exempt pursuant to a specific tax treaty. And then, of course, their passport and certain U.S. immigration forms. Let's go to the next slide. Okay. So we've determined that an employee is not a U.S. person and they are a non-resident. That doesn't get them out of the woods yet. The default U.S. rule is that a non-resident alien that performs services in the U.S. is taxable in the U.S. So that turns to more of a geographic tax basis. Now, if they earn income both inside and outside the U.S., then that will need to be allocated between the two jurisdictions. And the IRS looks very closely at that. Let's go to the next slide. So even if they're a non-resident, they're going to, the IRS looks at the income that they earned is statutorily taxable. And that's important because by statute, it's applicable. We're going to have to find an exception to ensure that what is paid, the wages paid to the employee are not reportable. So the first exception is very narrow, and it's that the non-resident is compensated by another non-resident, a non-US taxpayer who is not engaged in an American trade or business. The non-resident spends no more than 90 days in the US and makes no more than $3,000 from the services provided. The example that comes to mind is the foreign employee who comes to Orlando to spend a week at Walt Disney World and gets pulled onto an IT support issue while he's here on vacation with his family, and he earns no more than $3,000 during that particular period in doing that work for his employer who has otherwise no other connection to the US. So that's a very narrow exception. Let's go to the next slide. So in order to reduce that or expand that exception, we've got to look at tax treaties. An important point on tax treaties is to understand there are independent personal services and dependent personal services. Independent, think independent contractor, dependent personal services is an employee. Now, it's important to also understand that when a company engages an independent contractor, that is under current treaties, that gets included into the company's business profits or permanent establishment analysis to determine whether that company has sufficient contacts with the US to fall under US taxing jurisdiction. And then the dependent personal services are retitled as income from employment. Let's go to the next slide. So again, we want to look to tax treaties to determine whether an independent contractor is taxable, and the standards for an independent contractor include whether the individual has a fixed base in the US, and again, back to the 183-day requirement. And then we also look at the employees, again, that 183-day requirement. Now, there's an exception. If they're here less than 183 days, the income is not paid by an entity that itself is not a resident, and the wages that are paid are not borne by a U.S. permanent establishment, which means that those wages paid are not deductible by any other U.S. entity. Let's go to the next slide. This is just a general overview of the sources that we've discussed: salaries, wages, business income. It's generally where services are performed. Of course, we have some exceptions that apply. Royalties, scholarships, those are all dependent on where the property is used or where the education takes place. Let's go to the next slide. Okay, some other things to think about on the employer side. If an employer is determined to have an employee, the employer is obligated to withhold the tax and remit it to the IRS. The IRS considers that the employer is holding that tax in trust for the IRS. So if the employer does not remit, then it's considered to be a trust fund issue. Now, that gets to be particularly grating on the IRS if the amount is not remitted, because the IRS considers that money to belong to them. And if that is not paid to the IRS, then it has the ability not only to pursue the company, but to pursue the individuals who are responsible with check writing authority and payroll authority and expense authority at the company. So it's very important to understand who has authority within the company and ensure that your 940, 941 tax returns are filed in a timely manner. Note that the authority is what counts, and it doesn't matter whether the individual is a shareholder or a member of the company of the employer or not. Also, under tax treaties, we have some agreements that are not tax treaties, but they're called totalization agreements. And those allow for an equalization of Social Security, the FICA-FUTA withholding requirements across countries, only limited to the Social Security withholding level. So, for example, the US and Brazil do not have a tax treaty, but they do have a totalization agreement. So there are some of those to think about. Also, we have central withholding agreements, but those are largely available to athletes, entertainers, both inbound and outbound. Those are agreements that are negotiated ahead of time with the IRS. And so that the individual can go about performing their services without worrying about all of the withholding requirements that I've just discussed. Let's go to the next slide. There are multi-year compensation arrangements that we need to keep in mind. These are arrangements where services are performed in one year, but the compensation is paid in another year. We look at stock options. There's a vesting period from when the option is granted to when it vests. When vesting occurs, that's when it is taxable to the individual, but we have to look at the intervening period from grant to vesting to determine where the services were provided and, as I mentioned before, allocate based on where the individual was, which location the services benefited, and there's a series of analysis that occurs there. For example, we have a deferred compensation arrangement, 3-year vesting schedule. The employee works out of country 300 days each year. So they're in the US for 2 months every year. So 1/6 of their annual salary is attributable to US source income. The underlying salary undergoes that analysis. So the deferred compensation that is associated with that salary tags along and receives the same analysis. Let's go to the next slide. And that is what I just discussed is really what is described on this particular slide here. Let's go to the next slide. For retirement plans, there is a full analysis, a full understanding that we need to have of retirement plans, simply because a plan may be tax qualified or tax preferred in another jurisdiction does not mean that it's qualified under US rules. So there's an analysis that we need to go through as to what kind of interest does the employee hold in this overseas pension plan. It could incur passive foreign investment company interest that the employee has in this separate pension plan, or it could result in the employee considered to be a beneficiary of a grantor trust if it's determined that the foreign pension plan falls under more of a trust scenario analysis. So we need to make sure that all of the different components of that retirement plan are considered. Let's go to the next slide. It's very important. Tax treaties can clarify a lot of the retirement plan issues. And under this example, the US-UK tax treaty is fairly advanced or fairly well developed. In this particular case, we have a non-citizen comes to the US. They have a UK retirement plan interest. So it's potentially classified as a foreign grantor trust, which means that the employee, the income to that trust in a given tax year is potentially attributable to the employee, which would be problematic in the absence of a tax treaty. In this particular case, under the US-UK tax treaty, American tax is not normally owed until there's an actual distribution to the employee. So tax treaty to the rescue. The US-UK have been able to work out the issues with that particular arrangement. Let's go to the next slide. And I apologize if I'm moving a little quickly because there's a lot of ground to cover. Depending on the terms of the treaty, depending on whether the retirement plan is considered a PFIC or a grantor trust, there are different filing requirements for the employee, whether they have to file an 8938, which is an informational return. 8621 is annual reporting for foreign grantor trusts and for PFICs. And of course, the 3520, which is for beneficiaries of owners of foreign trusts. Let's go to the next slide. Okay, so foreign tax credits are typically, they are only applicable to US persons. So a foreign employer, a foreign company coming in is not typically entitled to what's called a foreign tax credit. It's a US person filing a US tax return, whether that person's a resident alien, green card holder, whoever it is, they're able to take credit for taxes that may have been paid to another country. And the general idea of the foreign tax credit serves on the next slide is to create an effective tax rate at the highest rate to which the individual or the person is liable. So again, going back to the US-UK, if UK source income is 25% and there is a tax liability, then we bring the highest US tax rate at 37%, a 12% functional tax is imposed by the US in order to bring her up to the maximum permitted tax rate. Likewise, or conversely, if the individual is taxed at a 40% tax rate in the UK, then the US imposes 0% tax because that's already over the maximum US tax rate. Now there are caps, there are groups into which these credits go, whether it's ordinary income, capital gains income, and so on. Let's go to the next slide. So those are foreign tax credits. Now, just a couple more considerations here. These are going into non-employee compensation issues. And like Jim mentioned at the top of the presentation, there is a patchwork of regulations across the US for state and local taxes to apply. Now, just to clarify, the US alone has over 11,000 taxing jurisdictions. I've only been talking about the federal tax rules so far. So there are over 11,000 state and local taxing jurisdictions. There are over 1,800 tax rules. Now, the map that you see has to do with forming economic nexus with a given state, which determines whether the company falls under state and local tax rules for a given state. There are other kinds of nexus that have been developed. Economic is the governing one right now. Now, in 2019, again, just not to put too fine a point on it, between the US and Canada, there were over 34,000 rate and taxability updates just in 2019. Also, in 2019, for state and local sales tax holiday rules, there were over 115,000 updates for state and local tax. So it's very important to keep an eye on a lot of these different considerations, how the employer needs to be structured, whether they are, let's go to the next slide. Whether they are forming a subsidiary, whether they continue as an overseas partnership, either way, there are different taxes that will apply that can flow through to the parent, whether that's branch profits tax, dividends, dividend equivalent, where dividends are attributed to what should be distributed to the overseas shareholder, taxes on excess interest if dividends are not distributed, if the subsidiary is thinly capitalized and instead leveraged through debt, then a de facto tax is still imposed under 163J. If there is if there's an indication that there's profit shifting occurring, then there's a base erosion anti-abuse tax, or BEAT, that is imposed, and that's under the current global tax project that the U.S. is participating in. Let's go to the next slide. And finally, the IRS is looking at a few issues on its that are on its docket. So under the Biden administration, they are focused on proper worker classification. A lot of employees are being classified as independent contractors. The IRS does not like that. They favor employees right now. And historically, the IRS favors employee classification, even though the president at any given time, last administration favored independent contractors, but the IRS still pushed back and favored employees. The IRS is closely reviewing deferred compensation plans. Also, proper allocation of services among jurisdictions. I mentioned that. In the COVID era, they are closely examining remote workers and ensuring that proper tax residency is determined. And then finally, in the digital era, there's cryptocurrency, and there are tighter reporting requirements on payment processing right now. So those are the 2022 hot button items for the IRS that they're looking at. All right, so I will throw it back to Jim. You there, Jim?
I am.
All right.
Now we're going to look at employment and labor distinctions here in the U.S. as compared to other jurisdictions. Just one note with respect to taxes, that is probably the single greatest need of companies coming into the U.S. is tax advice, and almost universally Even where companies have substantial a tax department, say in Europe, they absolutely will need local assistance here in the US with respect to taxes. So let's talk about employment and labor distinctions. Here in the US, we follow the format that I mentioned earlier of federal, state, and local laws. It's true with respect to wages and overtime, discrimination laws, and welfare plan benefits as opposed to pension plans, meaning medical or dental benefits, life insurance, and whatnot. I think the term that probably applies is regionality. There is a certain regionality to labor and employment laws here in the US. There are jurisdictions like California that have substantial regulation in the workplace. And there are other jurisdictions, for example, in the Southeast, like Mississippi or Alabama, that have substantially less regulation in that area. Some aspects of the labor and employment are governed solely by federal law. For the most part, for example, pension plans are governed by a law known as ERISA, and many aspects of executive compensation with respect to executives who work here in the US are governed by federal tax law. With respect to workplace safety considerations, again, those are generally federal standards, although I'm going to put a caveat there with respect to the pandemic and talk a little bit about what's happened over the last year or two. And the same thing with labor laws. Labor laws are a creature of federal law, and there are some state laws known as right to work laws, particularly in the southeastern portion of the US, that do come into play if they don't conflict with federal labor law. And then there's some aspects that are just governed by state law, such as workers' compensation or unemployment claims, where those laws are really a creature of the state in which the company is located. Next slide. So almost all employees here in the US are protected by an extensive network of discrimination laws. And they're protected in connection with, if they're in a protected class, that would be race, age, gender, disability, for example. They're protected against discrimination and retaliation in connection with engaging in so-called protected activities, which may be as simple as complaining about a discriminatory practice in the workplace. So companies coming into the US should expect to have substantial regulation within their workplaces related to discrimination laws, and that would be true for every state. They, in addition, would have to look at the city or locality in which they are located. Many cities in the United States have far different discrimination laws than even the state or the federal counterpart. So it's very critical to understand the locality that you would be moving into. It's also a very dynamic area. While there are some changes, for example, in, let's say tax law, employment law is on steroids when it comes to changes. Our laws change routinely, every year or two, and new concepts are developed. There are new cases that come out that change. So why don't we continue with workplace safety and COVID? So as many of you know, the US is in the middle of the pandemic and including a substantial upturn. And so when it comes to workplace safety, OSHA has been the agency that is charged here in the United States with carrying out workplace safety. Recently, the states have been engaging in pandemic-related legislation. And so it's important to understand on two levels. When it comes to normal risk in the workplace activities, such as being exposed to highly toxic chemicals, OSHA would have the ability at the federal level to substantially regulate that area and often preempt any contrary state law requirements. So if you are engaged in a manufacturing process, it's important to understand that you will have substantial scrutiny in connection with that workplace safety issues. But with the onset of COVID, workplace safety is actually being handled increasingly by federal agencies such as the CDC, OSHA, and CMS. But recently, with the Supreme Court decision staying many vaccine-related activities of the federal government, there's been a transition away to the states, particularly with respect to COVID. Next slide, please. So currently, the U.S. has a widely scattered set of regulations in connection with COVID. And it's important to understand that if you will have a workforce in several states, you will be subject to different laws as it pertains to mandatory vaccination and masking policies. Employers do have substantial ability to set those policies, but this is a substantial issue that's going on here in the U.S. currently, and we anticipate that it will continue. And so employers coming into the U.S. In the near future will have to determine what type of national policy they will have if they have multi-state presence here in the U.S. Next slide, please. Scott, I think you're taking it over at this point.
Yeah, thanks, Jim. Good morning, everybody. My name is Scott Cash. I'm in the commercial litigation group at White & Williams, based in our Manhattan and Stamford, Connecticut offices. I'm going to talk just for a minute on this last slide on employment and labor issues about employee handbooks and manuals. So in the United States, employers almost universally have employee handbooks or manuals that describe the policies that govern the workplace, the workforce. The key components of the manuals include policies on discrimination, harassment, retaliation, wage and overtime policies, paid time off, and often code of conduct requirements. Failure to have a handbook can subject an employer to potential liability. And in compiling the handbook policies of the foreign entity may not be applicable or may be problematic. Important to ensure that all employees receive a copy of the handbook and that their receipt of that handbook is documented and that there is some training during the course of the year or perhaps every other year on the handbook. We could switch slides. Let's see. Go one more forward. Yeah, great. Thanks. Okay. There we go. So I want to switch gears now and talk about restrictive covenant agreements. In the broadest sense, a restrictive covenant is any contractual provision that prohibits or limits an individual's right to engage in certain types of employment, engage in certain conduct and competition with an employer, or use certain information or utilize techniques or practices developed by the employer. We can go to the next slide, please. The restrictive covenant may apply to the time when the individual's employment with the employer is ongoing, after his or her employment terminates, or both. Next slide, please. Like many contractual provisions, restrictive covenants come in many forms. There's a non-competition covenant, commonly referred to as a non-compete. There's a non-solicitation covenant, a non-acceptance of work covenant, confidentiality and non-disclosure covenants. Despite their differences in name, non-competition, non-solicits, non-acceptance covenants are sometimes collectively and colloquially referred to as non-competes, but they're not all necessarily non-competition agreements. Next slide, please. So these agreements are designed to prohibit or restrict an individual from competing with his or her current and or former employer, accepting employment with a known direct competitor, accepting employment with a company that provides competing services, even if it's not its primary or entire business, starting a competing business, providing consulting services for the benefit of a competing business, and sometimes acquiring an interest in or serving in an advisory capacity to a competing business. Next slide, please. A non-solicitation agreement is designed to prohibit or restrict an individual from engaging in solicitation for his or her benefit or for the benefit of a competitor. And this can include solicitation of customers or clients of his or her employer, prospective customers or clients of the employer, employees of the employer, partner vendors or service providers that are typically utilized by the employer. And some covenants purport to also broadly prohibit interference with any or all of the above relationships. They're not just limited to one or two. Next slide, please. So the non-acceptance covenant is sort of a hybrid covenant. It's often made as part of a more traditional non-solicitation covenant in an employee agreement. It's designed to streamline the level of proof required to demonstrate a breach of a non-solicit covenant and or provide a recourse in the event of a so-called passive solicitation of customers, clients, and employees. So it prohibits or restricts an individual from accepting business from customers or clients of his employer, regardless of whether there was solicitation. If the individual has accepted the business from and is servicing or working on that business, it could be a breach of the agreement. It also prohibits or restricts an individual from facilitating the transfer of business of a customer or client of his or her employer to a competitive business or person. It prohibits or restricts an individual from hiring a former colleague or employees of the employer. Next slide, please. So the confidentiality and non-disclosure covenants are sort of in their own category. They are designed to prohibit and restrict an individual's possession, use, and or disclosure of the employer's quote unquote confidential information. And confidential information is typically defined in the agreement. It's defined in court decisions in various jurisdictions, but it oftentimes means and ranges from anywhere between information that is not generally available to the public, to the employer's own compilations of publicly available information, proprietary trade secret information. Certain confidential information is protected by law, even without a contractual provision. So you could have a separate cause of action if there is litigation beyond just a breach of contract for a violation of a particular state's law that protects the use of confidential information. Next slide, please. So what types of companies use restrictive covenants and why? Companies from all different industries use restrictive covenant agreements to protect business interests. The business interests companies seek to protect can include sensitive, confidential, proprietary business information, client or customer goodwill, lists or identifying information about clients, proprietary techniques or processes, competitive pricing information, and the list goes on. White & Williams routinely handles restrictive covenant matters for clients in the healthcare, insurance brokerage, pharmaceutical industries, and have also handled restrictive covenant matters involving executive recruiting firms, retail stores, beauty salons, investment firms, and the like. Next slide, please. So the big question is, are restrictive covenant agreements enforceable? Well, it depends on a number of factors, but typically it depends on which state law applies to the interpretation of the restrictive covenant agreements. For example, courts applying California law typically will not enforce restrictive covenant agreements because they are against California public policy. In Massachusetts, for example, there's a relatively recent law that limits or narrows the permissible scope of restrictive covenant agreements. Some states prohibit enforcement against certain professions. Delaware, Massachusetts, Rhode Island prohibit non-competes as applied to physicians, for example. New Jersey is pending legislation to limit the type of employees who can avail themselves of non-compete covenants, as well as limitations on permitted temporal and geographic scope. There are discussions happening on a federal level about restrictions on non-competition agreements. Typically, these agreements will not apply to lawyers because of the attorney-client relationship. Enforcement also depends on the scope of the restrictive covenant agreement. How broad is it geographically? How long does it last? How big is the list of clients or customers to which it applies? Next slide, please. So another issue to consider in deciding whether to enforce and go to court to enforce a restrictive covenant agreement is whether there's sufficient proof, sufficient evidence that the agreement on the covenant was violated. So the first step, of course, is to look at the agreement itself, the covenant itself. Is it enforceable as drafted under your particular state law? Business considerations to take into account, the costs of enforcement, not only the legal fees, but the lost employee time for putting together a litigation, the impact on existing client relationships, employee messaging and company culture, and also the press, both in the formal sense and through informal channels within the industry. Next slide, please. So you have to be ready for challenges to the enforcement of restrictive covenant agreement if you're going into court to try to enforce one. The courts treat restrictive covenant agreements like they would any other contract in certain respects. So the court will ask, was there acceptance of the terms by the employee? Was there adequate consideration given to the employee in exchange for their agreement to the covenant? Is the restrictive covenant agreement generally enforceable under the state law? Is the duration reasonable? Is the geographic scope reasonable? Next slide, please. Other issues that the court is going to consider when examining a restrictive covenant agreement is to determine whether it would be equitable to enforce the agreement. Would it unduly burden the employee to enforce the agreement? Did the employer comply with all of its obligations, contractual obligations? Is the restrictive covenant agreement narrowly tailored? That is, not more restrictive than necessary to protect the employer's legitimate protectable business interests? And of course, is there proof of a breach of the agreement by the employee? Next slide, please. So if you are going to decide to enforce a restrictive covenant agreement, how do you go about doing that? There's a couple different ways. You can seek an equitable remedy designed to stop ongoing harm or injury and prevent future harm. That's a temporary restraining order, also known as a TRO, sometimes known as a special injunction or emergency injunction. And this is typically for emergency situations only. So seeking a TRO signals to the court that the issue is so time sensitive that the parties should jump to the front of the line in the courthouse to be heard. Truly, it is temporary, just to preserve and restore the status quo until a full hearing on the merits can be held before the court. Another step is a preliminary injunction that would be after a temporary restraining order. That's for emergent matters. Sometimes the courts will permit limited expedited discovery, depositions, document exchanges, and then that's followed by a hearing, typically with testimony by live witnesses. And then following that, there's permanent injunction, which typically comes at the end of the case. Next slide, please. One of the most common challenges to an action to enforce a restrictive covenant agreement is that money can satisfy any harm that was caused, that is alleged to have been caused. So if the defendant can show that a plaintiff can be made whole with money, for example, recouping lost profits, then a court may deny a request for equitable relief in the form of a TRO or preliminary injunction or even permanent injunction. In that case, the action really becomes one just for breach of contract and money damages. Also, the former employee's new employer can be brought into the case if there's evidence that the new employer intentionally interfered with the restrictive covenant agreement or engaged in some unfair competition and or conspired to cause the former employer damage. Next slide, please. We regularly provide our clients with educational presentations on these and other issues, so feel free to reach out to us if you want a more in-depth program on this or any other topics that we've covered today. just given the time constraints. So I'm going to hand it off now to my partner, Bruce McLennan, to discuss intellectual property.
Thank you, Scott.
Yeah, I think Bruce, you and I, would you like me to do this, Bruce, or?
Either way, you want to go for it, Jim?
Yeah, sure.
All right.
Feel free to chime in, Bruce. So let me just make a couple comments. First of all, with respect to companies coming into the U.S., just getting back to restrictive covenants, when you hire employees here in the U.S., you should assume that they are likely subject to non-compete agreements or confidentiality agreements or agreements involving assignment of inventions. It's very common here in the US, particularly at the management level and certainly at the C-suite level, to have those types of agreements. So if you're not familiar with those types of agreements, and many countries don't utilize them to the extent that they're utilized here in the US, it's important for hiring purposes to be aware that the people that you're hiring may be subject to those types of agreements. And as an employer, the new employer, you may be prevented from utilizing that individual. It's one area that historically, I think many countries coming here in the US have had troubles with. I want to say a few words about intellectual property, just sort of a segue here. Scott was talking about restrictive covenants. Often restrictive covenants talk about confidential information, and it could be trade secret information. And I'm going to be talking about intellectual property. Now, within intellectual property is the concept of trade secret information, which can either be in some states regulated by statutes or alternatively by the common law. However, with respect to other types of intellectual property, we have a federal system which is operated through the U.S. Patent and Trademark Office, as well as the U.S. Copyright Office. So it's important to see that distinction with respect to trade secret information, which may not be protected within the U.S. Patent and Trademark Office. It could be things like company know-how, client customer base, the traditional types of areas that are protected under the restatement. We have a restatement here that deals with trade secret information. And that would be the type of, and it would typically be resolved in state or federal court, those types of issues. However, if you're in the US and you're either developing IP or utilizing IP from a foreign country, it's important to look at whether you need to register your IP here in the US to have protectable rights. Generally, foreign companies seeking to protect their existing IP or their new IP developed here in the US will file for such protections. The filing process is not complicated here in the US with respect to copyrights and trademarks, but is highly complex with respect to patents. The US recognizes common law rights in the copyright and trademark areas, but the remedies are substantially limited from what a company could expect if it files its IP in the trademark or copyright area with the US Patent and Trademark Office. The process is generally a long one. With respect to copyrights, it's much shorter. Copyrights can be filed quickly, and common law copyright can be converted to a file protectable copyright in our system fairly quickly. Trademarks take a bit longer, but relatively speaking, compared to patents, it's a much faster process. Conversely, patents can take quite a while to perfect here in the US, and sometimes trademarks can take a while. We have a process in which competitors can object to certain filings, and those objections can take the place of administrative proceedings before the US Patent and Trademark Office, or often in federal court. And so it's typically the case that some of the areas in which a company may want to protect its IP could be subject to challenges, but more often than not, particularly in the copyright and trademark area that's generally not the case. With respect to patents, however, it's important to understand by engaging, quite frankly, a patent attorney to understand whether your patent may infringe someone else's patent, or whether you have the ability to operate without needing a patent. And it's a complicated process that often begins before any type of filing occurs. And so there are different steps to it. It's the evaluation process and then the filing process. Next slide. The patent process is also highly specialized. While in other countries around the world, you can file for patents, here in the US, it's often the case that, for example, a patent in the electronic engineering area requires one type of expert and an analysis, and can be highly complex. Whereas, for example, a patent in the life sciences area not only could be subject to the Patent and Trademark Office, but also FDA concerns as well. So if you have an area that you believe will be patented, it's extremely important to begin the process early, to get advice, and then maybe most importantly, look at specifically what area you would be seeking patent protection in, because some areas are far easier than others, where, for example, in the life sciences area, it will require an expert in life sciences patent work in order to be able to accomplish the evaluation and review that would be necessary. The lifetime of a patent can be limited depending on what the patent is for. It will depend on a number of different things. Trademarks, however, can be renewed, and often are renewed for many decades. And as they become renewed from, say, decade to decade, they become far more valuable. Example, Coca-Cola is a trademark, and obviously its value is substantial. Copyrights also have limited limits, but they're decades old. Next slide, please. And companies in the US also have invention assignment agreements, which are typical. You see this most often in companies that are dealing with creating technology and creating work that could be patentable. It's called the right for hire doctrine here in the United States. And employees agreed, and consultants as well. And it's important to understand that consultants, it's important to have contracts with them, not just employees, to assign their rights to technology that may be developed within the workplace or within the company. Most companies have extensive confidentiality and trade secret agreements with employees to protect IP. Could be the software industry, it could be robotics. I think we talked about a few technology sectors, but it's very common here in the United States, and becoming far more common to have these types of agreements. These agreements are routinely enforced when an employee seeks to violate them by disclosing, for example, trade secrets to competitors, we've discussed in the restrictive covenant discussion. Next slide, please. I want to say a few words about local insurance requirements, and I see it's approximately 1:15. We will stay around to take questions, a little bit of housekeeping at this point. We will be making a set of the slides available to anyone who may request, and as noted in the invitation, our program is being recorded today, and we will make a link available to the recording if anyone in your organization would like to look at this. So let's talk about local insurance requirements. While most US employers work with professional insurance brokers to sell certain products within various insurance portfolios, there are certain types of insurance that are mandatory here in the United States. All companies must have them. One example of that is workers' compensation insurance. A major difference here in the US compared to the rest of the world is that the US does not have state-sponsored healthcare. There is no national healthcare in the US. Instead, healthcare is governed typically by health insurance that are provided by various insurance companies. If you are a national employer seeking insurance across the United States, you may essentially be limited to 4 or 5 national health insurance providers. Many employers here in the United States are self-insured. It is much easier to have insurance through an insurance company than to be a self-insured company or employer here in the United States. It is highly regulated and quite complicated. Most employees here in the United States receive healthcare through their employers. And as mentioned, health insurance can be a very complicated process. The next slide, please. So depending on the nature of your operations, almost the vast majority of companies here in the United States have liability and casualty insurance. And if you're seeking to do business here in the United States, most of your vendors will require proof that you have those types of insurances in order to enter into contracts with you. So it essentially, while not technically required, it's practically required if you're going to do business here in the US. Companies that sell products, in almost all instances, have product liability insurance, and those who provide services generally have what's known as errors and omissions coverage. Most companies do have a fairly significant portfolio of different types of insurance coverages. Many companies have, in addition to those insurances, fiduciary liability insurance with respect to their benefit plan. Employee theft policies are fairly common and are part of an overall executive liability product that many insurers now sell, where employers can, under one policy, determine what types of insurances they would like to enter into with different limits of coverage, different deductibles. And as I said, brokers are very used to dealing with foreign companies coming into the US and can provide substantial guidance in that regard. Next slide, please. Another type of insurance is directors and officers insurance, or D&O insurance. It's extremely common with medium to large companies, but now even small companies are purchasing this insurance as well. As the name implies, it protects officers and directors against claims by third parties relating to business operations. It is not uncommon for directors and officers to be sued here in the United States. And so the majority of companies choose to have that type of insurance. And even, as I said, even small companies are now moving into that area as well in terms of their portfolio. EPL insurance, employment practices liability, is now held by the vast majority of US employers. It is highly recommended that if you are doing, you will have employees here in the United States, that you have that type of coverage. And there are also specialty insurance products like cyber liability coverage, media peril insurance, and even so-called rep and warranty insurance in connection with mergers and acquisitions are becoming far more prevalent than, say, even 5 years ago. So the US insurance marketplace is extremely active and growing, and there are a lot of customized specialty products. Many foreign companies have a portfolio within their home country, and they can often customize their global operations by seeking a global portfolio of insurance products. That is highly common for multinational companies to lay out their entire insurance structure in that regard, and they will work with national brokers in that case. Next slide, please. So we're at the end of the program. I want to thank everyone for attending today. I see that we have a few minutes left. Sorry about that little glitch there. And at this juncture, why don't we, again, just to note, the materials will be available. We'll be sending links to those out to all the attendees. In addition, we will be sending a link to the recorded program if you ask for that. At this juncture, if anyone has any questions for our panelists, please let us know. Using either the Q&A function would be the preferable method for asking questions. And we'll just wait for a few minutes to see if we receive any questions. And while we're waiting, again, want to thank everyone for attending. Want to thank our panelists for a great presentation. I know we got quite a bit of information thrown at you today, but we will be available. We've given you the email addresses of all the panelists so that if anyone has any specific question that they would like to address to any of our panelists, you can see them on this slide, and you also have their direct phone numbers that you can use if you'd like to reach out to them. So why don't we give folks about another minute or two to see if we have any questions on the Q&A slide and the Q&A function. The panelists, any final comments while we're waiting? I guess not. Okay.
Yeah.
Okay, great. I don't see any questions, so I think we're just going to wrap it up at this point and thank everyone for attending. Look forward to seeing you at our next program. Thanks so much and have a great day.
Thank you.